Court is getting started. Just make sure I know you taking away our content. You're streaming on your channels, but this is the Heavy Media.
Worship we are before. I love to pray. Mr. Thomas Dati, Mr. DPP, Mr. Lutale, the Father of the State, and Mr. Elias Lukwago, Self-Frederick Mpanga, Apollo Katumba, Adubeka Sekanjako, Cyrus Ojuru, Brian Limwawe, and Mr. Luka Mlegiana, for the respondents. The worship just before my colleagues come, because they haven't started. So we just don't take them by ambush. We just thought we should emphasize.
No, my lord, I think at this level, without due respect, it is the respondent that, or the applicant, the respondent in that application, that made a prayer to stand over to make up. So, if the applicants have anything to say, let them wait in the argument. There is nothing to clarify right now. They had all that time. It was the application. It was this application. It looks weird for the applicant to come and say, before you come, let me clarify. We are ready to respond and we are ready to do your worship.
Worship, I think we want to submit an offering.
Should have been submitted that
And
time.
my Lord, and your worship, I think it's a court of law. And we can seek leave of court. Mr. Philip Ubuka, even though he has the might state, he's just like us, he's ordinary. So you shouldn't assume that because there's the comfort of an office of DPP, can come here and push us around. I am seeking leave of court, address court before he comes on, because it will help him wouldn't be bringing this situation. I am seeking leave of court.
Your worship, there is nothing to say on. First of all, this court has the discretion to grant it or not. There was an application which was made by senior counsel and he ably submitted. He shook this court in submissions. And that's the reason why we applied for a standover to have our response. It is therefore not fair for them to make bad and good their own case before we respond. Let them allow us to respond. There's nothing we need from the applicants to help us. It is the application, so we pray that the application for leave to make clarification is denied, so that we respond, because they have time to rejoin.
Well, before we step out, the applicant had aptly put his application before court. And it was the respondent who asked for standover. So let's listen to the respondent.
Also glad. Josh, in response to the application, first of all, By the time Senior Counsel Lubako made the application to stay the proceedings and also asked for the record, this court had made a ruling to the effect that the application number 01 of 2025 be had in chambers. As the magistrate or the trial magistrate was standing up, counsel simply said he has an application to make. That in itself was irregular. Because at that time, the hands for applicants and the respondents were tied because the ruling had been made. The only way senior counsel was, by all means, supposed to make that application was to seek leave of this court, which he never sought. That in itself hits the applicant's hands down. That said, my senior colleague talked about so many things, including jeopardizing the case for applicants. However, we on record as prosecution for ensuring an expeditious trial, an expeditious investigation in this matter. We wish this court to take a note of the fact that the prosecution is being twisted by the accused persons, in which case the intention is to delay both the investigations and the trial. So, on the other hand, as prosecution is trying to execute its mandate, it is being blocked, it's being frustrated, it's being twisted by the defense, which shouldn't have been the case. We expected the defense to be the main facilitators of the first investigations and the trial of this matter, but we are surprised. Defense made an application and cited several provisions of the law. He cited section 17A of the Judicial Act, 17.1 of the Judicial Act, which talks about the supervisory powers of the High Court over Magistrates' Courts.
As long as I'm not captured there.
Most obliged. And also cited there, he cited the section 33 of the Judicial Act. Let me read it verbatim, because we want the press to hear. They are bringing this application under section 33, which talks about treatment of life imprisonment or imprisonment for life in any enactment. That is the law under which the application was brought. This is bad law. This is bad law. The details are there, and we wish court to capture it as part of the application. 2, counsel made a prayer to stay proceedings, that this court stays proceedings. However, that assertion, or that prayer, sorry, is not grounded. He never provided or cited any authority, either statutory or case law, that gives this court, empowers this court to stay its own proceedings in a scenario where it has been just informed by the applicants that they intend or they anticipate to make an application for revision in the High Court. This court is not supernatural. This is not a court of prophecy that will determine that the applicants are going to make an application for revision in a 2 or 3 or 1 month time. The only court that has the powers to stay the proceedings before this court is the court that is doing the revision. And therefore, the applicants to that effect in this application should first of all have sought that order from the court that will hear the application for revision. Because that court has control over proceedings, and therefore it can tell the timelines that the said application will be heard and disposed of. And therefore it is redundant. It is a redundant prayer to ask for stay of proceedings in a lower court. This court cannot again stay proceedings before it without evidence that an application for revision has been made. We don't operate in anticipation. Courts of law operate on facts and evidence. So the issue is, what if the applicants filed the application for revision after 1 year? So our view, my colleague will submit on the record of proceedings, but I am of the view that this court does not have powers to stay its own proceedings without grounded statutory law and case law. We were supposed to have this matter heard in chambers, and I believe that this court will not have had in any way to have application number 01 of 2025 heard today and disposed of, so that we fast track the investigations in this matter and ensure a speedy trial for the applicants in the main case, that is 008 of 2025. The public, Your Worship, my senior colleagues have been about that, how it's going to be placed. The public and the press have less contribution in application number 01 of 2025, because they are not going to make an argument before this court. None of them saw an affidavit on record. And therefore, their input is at the periphery. Their role is peripheral, if I'm to say it. My colleague will add on that.
For the record, I'm Chico Thomas, assistant. Your Honor, it is very prudent that the sections that have been cited by our land friends, that is section 17, which gives supervisory powers to the High Court over the Magistrates Court, and sections 48 and 50 under the Criminal Procedure Code that purposely relate to the nature of proceedings in revision, gives the High Court these powers to call for and examine the record of any criminal proceedings before a magistrate's court for purposes of satisfying itself as to the correctness, the legality, the propriety of any finding, sentence, or order recorded or passed, such as the one this honorable court gave, and as to the regularity of any proceedings of this court. These powers are solely given to the High Court, and therefore, for the defense purport to ask this honorable court to inherit itself of these powers is not correct. The leave of court that my colleague earlier commented on or submitted that they should have sought leave from this honorable court. It is their right to apply for a record of proceedings and ruling of this court. However, for it to be the basis upon which they want to file an anticipatory revision, it should not be entertained by this honorable. And it is our humble prayer that it is misconceived and they should file this application before the right court as they have allotted. And we pray that this honorable court be pleased to have this matter as directed and in its order. So that.
Thank you, Your Worship. Your Worship, what I wanted to do was to put things in clear perspective. Yes, I am responding so that my colleagues respond appropriately. My senior colleague, Mr. Premise the application in section 14. That was his section. He referred to section 17 in support of section 14. What he said was that he had instructions to refer the matter to revision. It is in section 48 and not section 17. Your Worship, under the Judicial Criminal Procedure Application Rules, SI 13-8, that process can be commenced by letter. It is therefore erroneous, and perhaps deliberately so, because I don't want to assume that it doesn't, that you don't need for an application. So when council says you can't file an application in 1 year, I don't want to assume that you are letting go of the process. It wouldn't surely take council 1 year to write. In any event, the letter has been written, and perhaps the systems would have shown you that the application is there. Your Worship, the instructions of the applicants are to seek a revision, not an appeal. The sections cited do not require leave of this court, and we need to be emphatic. We are not here to ask for permission of this court it is a right for the matter it is nowhere indicated that we must seek permission of this court. So again, because I know that Mr. Beautiful cannot see this, I don't want to assume that circumstances are causing him to do what is wrong, especially when it's still the early part of the month, when all of us have just been paid.
Let counsel please. The matters that are now before court.
I agree with my style to be emphatic that when the government has injected resources, we ought to do the right thing, because that's what we are calling. So, Your Worship, what Land Council Elias said was to inform court that we are going up to the higher court. To repeat, we do not need permission of this court because it's not provided for anywhere in any law. It also ought to be remembered, Your Worship, because Council was saying we should have filed an application. We don't have the benefit of lead cuts like him. This matter was stood over for 30 minutes. We could not go away to file an application and come back to this court in 30 minutes. We were just good manner to say we are going to a higher court. Please hold on until the higher court makes a pronouncement about the matter. My colleagues referred to the lack of an authority. It is what I was going to refer to when he quickly stopped me. Unfortunately, now that he stopped me, he wouldn't have an opportunity to respond to it because he would have, had only been a little patient. Your Worship, it is common sense that if the High Court is going to review proceedings in the lower court, the file of the lower court must be before the High Court. So when the application is filed, and it will indeed be filed today, the High Court will make a pronouncement to call the file. For this court to proceed with the cross-examination in camera and end today, when we are seeking a review of that decision, would surely not make sense. That's what I'm saying, it's common sense. Because then there will be nothing to review because the cross-examination has happened. We don't want to take the people through the debugger of returning if the court says, but we should do it in the open. It's common sense. Your Worship, also, the spirit of our argument is founded in the well-known decision of Charles Onyango Obo and Andrew Mujuni Mwenda versus the Attorney General. Your Worship is the one I wanted to point my colleague to when he said I shouldn't. In that court, my Lord, it is Constitutional Appeal number 2 of 2002, Supreme Court of Uganda. His earlier submission was that the High Court doesn't bind this court. I hope you will agree on the Supreme Court binds this court. Your Worship, in that decision, the Honorable Justice Mulenga, RIP, who delivered the lead judgment, said that when a court seized with a matter becomes aware that the proceedings are under challenge or are going to be a subject of the challenge, it must wait for the decision of the higher court. The rationale is to avoid a perversity of justice and to avoid applying the law or taking action whose validity is questionable. In other words, it should wait for the higher court to make a pronouncement as to whether it should continue or not continue. That is what we are saying. We are going to the High Court, which, as far as we know, is higher than this court, and it is only good, even for the record and the judicial officer, to wait for the higher court. You want to avoid a scenario, as happened in the decision of the Honorable Moses Kasivante and Paraminda C, where the lower court went ahead to conduct a recount, despite the matters being challenged by the High Court before the Honorable Justice V.F. Musoke Chibuka, RIP, whereby the judicial officer at the lower court became a subject of disciplinary proceedings. We want to avoid that scenario and say that let the court wait and we go to the High Court. We are reminded, my Lord, and we go to section 50, subsection 2 of the Criminal Procedure Act. Your Worship, the position of that section, section 50, subsection 2, is that a review cannot take place without the DPP being heard. So those proceedings of under review, these ones are going to be under review, are going to involve the DPP. It is in that forum that the DPP is heard audience. The DPP cannot object to an accused person seeking to enforce their rights. It is wrong. I want to assume that if my two colleagues were in the dock, they would be ashamed and angry at someone standing in their way of enforcing their rights. So it is wrong for Mr. Billy Kumbuka to argue that when an accused is seeking to enforce their right, they are frustrating a process. The accused persons are not the authors of the law. They are relying on a provision of the law which they are entitled to. It doesn't matter that relying on that provision of the law causes proceedings to stay. It is their right to do so, and they are fully entitled to invoke that right. In any case, Your Worship, unlike the state and these two representatives here, it is the accused person who have no liberty. So if the delay is going to cause them to go back to prison, I shudder to think of the concept of Mr. Billy. They are taking the risk of sacrificing their liberty to see that the right thing is done, and they are empowered fully and to invoke the right. Your Worship, I wish to conclude. By saying that the arguments by my colleagues cannot stand in the way of the rights of the accused person. The rights are provided for by law. They don't have their liberty. They choose to invoke that right. They take the inconvenience that come to revoke it. And lastly, Your Worship, because our colleagues blamed us for paying this application before we filed a formal application, we just state that this court stood over the matter. The accused persons were returned to custody, which is under very tough guard, as can be seen. We didn't ask, so we didn't speak to them. We had to obey orders and stay here and wait for court. But again, as my land friend Mr. Judicial said, we are not asking this court to revise this decision because it doesn't have that power. We are asking the court to do what we think is reasonable, to hold on to continuing with the decision it made until the higher court revisits that decision. It is not an appeal. It's not brought under section 17. It is brought under section 48, which, if once the application is filed, the High Court will call that file. So it is not proper to take your time to sit in an application to hear cross-examination when there is a possibility that those proceedings will be recorded if the court agrees that the hearing should not proceed. That's our submission.
Respect to only two issues. One, the jurisdiction of this honorable court in regards to say of its own proceedings. Our friends across the aisle argue that we do not cite any provision enjoining this court to stay its own proceedings. In other words, they are suggesting there is a vacuum. The strongly contained the famous of the law do not leave any vacuum in that regard. In the contrary, Your Worship, this court has unfettered powers to manage its own proceedings and processes in situations of this nature. We refer you, Your Worship, the provisions of Section 9 of the Magistrates Courts Act. If I may, Your Worship, just for emphasis sake, to read it out verbatim, how general jurisdiction is exercised. The jurisdiction of the Magistrates Court shall, subject to this Act and any other written law, limiting or otherwise. Yes. Let me get this one, read it from this volume. How general jurisdiction is exercised. The jurisdiction of the Magistrates Court shall, subject to this Act and any other written law, limiting or otherwise relating to the jurisdiction of that court or of the presiding magistrate, be exercised in conformity with the law with which the High Court is required to conform, and exercising its jurisdiction by the Judicial Act. Your Worship, my interpretation of this particular provision is court is broad with wide jurisdiction, just like the High Court has got or enjoys that wide discretionary power in managing its processes. And I think this answers their question as to the applicability of Section 53. It seems now they are satisfied that Section 33, the former Section 33, sorry, of the Judicial Act. Therefore, here we are getting acclimatized to the revised definition, and that's not the deal. So, Your Worship, the wide discretionary powers enjoyed by the High Court under the Judicial Act are the same discretionary powers vested in this honorable court, including powers to stay its own proceedings. And this reinforces the issue of logic that my young friend succinctly submitted on that particular time. And that also resonates with the spirit of Section 43 of the Judicial Act. That is the former provision. I wish to correct that. Having said that, Your Worship, just to re-emphasize it, because now they argue that what if it takes a year before we fight? That again brings me to the powers under Section 9 of this majesty to manage its own proceedings. Your Worship, you have powers to set timelines. Say, yes, we recognize you have a right to seek for the intervention of the Superior Court by way of revision, but it's not an open check. And of course, we can draw parallels with appeals. That's why even appeals have got timelines, that you have a right to appeal within 14 days. You have a right to appeal within 30 days. So it's very simple here for the court to invoke its powers under Section 9 and 43 of the Section 9 of the Magistrate Courts Act and 43 of the Judicial Act to say, yes, we recognize you have the right, and you have clearly indicated that you are pursuing that right. We are adjourning these proceedings for a period of 2 weeks, those are 14 days, within which that right should be exercised. And in that way, justice will be done. But now look at the absurdity. If you are denied that right now you retreat to the chambers, you go ahead with cross-examination, but still tell the accused persons or the applicants in this matter that you have a right to seek for revision of my order, when actually you have proceeded with the cross-examination. Would that even make sense? This is what we are trying to avert. That actually, if you proceeded that way, Your Worship, you will be rendering the right to seek for revision illusory. It will be negatory. It will be useless. And that will be a travesty. And that's what we are trying to challenge. And actually, it will make matters worse. And it will reinforce further our application for revision if you proceeded, Your Worship. To reinforce the last one, Your Worship, the accusations made against us. Very, very unfair. I don't know the words Mr. Barikun used. I'm twisting, blackmailing, doing this. He used lots of words. They were very, very unfair. Very, very unfair. I think he owes us an apology. Should retract those statements with an apology. We are here to facilitate this court to dispense justice, not to block the way to justice. If anything, actually, it's our client who are craving justice, who are interested in having justice done to them. This is not justice to Mr. Barikun. It's not justice to any of this, but it is justice to the applicants. So it would be very, very unfair, most unfair, to tell the accused persons who are seeking to enforce their rights, to get justice, that they are twisting the court, that they are blackmailing the court. Very, very unfair. So I pray that he reflects on this, and before ruling is made, he accepts to have that expanded from the record. I am appealing to his good sense and conscience, to his conscience. I do so pray, Your Worship.
Your Worship, I think the defense should be the one to apologize, because they have been using very, very hard and disgusting language. So they should be the ones to apologize to that prosecution. We have nothing to apologize in this respect. We are being more cordial, we are being courteous, we are being professional, to mention but a few. And God and the public can attest to this.
Your Worship, we seek to apologize to our colleagues for being extremely aggressive and steadfast and quite emphatic and perhaps overboard, but for the purpose of seeking to see that justice is done to our clients who are facing a charge which has a sentence of death and which is being pursued by our two colleagues to whom please do apologize.
cyane litujjo mugamba eri waliyo omusa mubi atuwa 360 olya luli bakutumira nga manyi oli awo mu studio egamba yoyo amina wange kituufu like and comment, subscribe, like and comment. You live on the Heavy Media. You are live on the Heavy Media. This is what they call the Heavy Media. You are live on the Heavy Media. Subscribe, like and comment, share this one and we make it happen. It is the Heavy Media. It is the heavy media. Wherever you are watching us from, it is the Heavy Media reporting live at Kawa Court. That is Dr. Kizza Besigye. You are watching the Heavy Media live. You are watching the Heavy Media live. Subscribe, like and comment. Subscribe, like and comment. Simply tell me where are you watching us from. To the hackers, for those of you who use our footage, our live feed to broadcast on your channels, you better come into the court. You better come onto the location. Start.
This is the ruling. Having heard from both parties involved, it's true that the application for revision is not yet filed and therefore anticipatory at this point in time. The normal procedure, as the defense has put it, is to file at High Court, which calls for the report. They have, however, indicated that times of the instance, and since the court made the ruling this very day to proceed with the cross-examination, should court continue with the hearing of the said application, the rights of the accused to apply for revision will become upon. Yes, this court can stay its own proceedings, but only upon proof of an application at High Court, for which the High Court itself will call for the file, not in cases of anticipatory matters to be filed. However, to enable the accused persons exercise the right, this court shall adjourn this matter from motion to the 30th of April 2025.
The matter is adjourned 30th of April. The matter is being adjourned. The main suit is coming.
Order, please. May it please, Your Worship. I think introductions have been made initially.
Your Worship, for the record, I'm Councillor Simon Nsumbuga, representing County Minnesota. Nsumbuga.
Your Worship, this matter is subject to violation and inquiry in the Senate. As you recall, as such, seek an adjournment
All the accused persons are further represented at your bedroom formation.
Dokta nalina inakyayagala okwogera. The court is done.
Why don't we?
Kale tubebaza okuva kitandikidde okusaawa 4 okutuusa mu kadde kano nga mukyalina ffe tukyatambula bamu wetuwuzikidde nga Lukwago bannamateeka ba hajji obedi lutale ne kizza Besigye nga basabye omulamuzi nti bamutegeeza nti bagenda kujulira nga bawakanya omulamuzi kyahazeewo okuba nti abalagidde babe nga babuuza ali mu kunoonyereza ku musango guno babadde basabye nti bamusoye kajujjo y'ebibuuzo oba kiyite cross-examination mu lujjudde bo state kyeganye so kati Elias Lukwago n'agamba nti bo tebajja kukkiriza kugenda mu chambers kubuuza musirikale ono bibuuzo byabwe baga kumubuuza nga tebali bannamawulire nga n'abantu ba bulijjo webali. So omulamuzi bwayisiza ekiragiro ekyo n'agamba nti bagende mu chambers. Counsel Elias Lukwago n'asituka n'agamba nti balina instructions oba balina ebiragiro okuva ew'abantu baabwe nti bagende bajulire okusalawo kw'omulamuzi ono okugaana abantu ba bulijjo okubeerawo nga babuuza oba basoya kajujjo y'ebibuuzo omusirikale ono. Era webiggweredde omulamuzi akkiriza bagamba nti kale kituufu baddembe okweyongerayo ogenda mu kooti esinga kweno bajulire okusalawo okwo. Era omulamuzi abawadde nti singa batukisana kuza omwezi nga 3 omwezi guno tebanateekayo kusaba okwo bajja kuddamu bakomewo bawulire application eyo. Era kuza omwezi zimu eza 3 agambye nti agenda kuba nga addamu okuwulira oba mention oba okusomera abantu bano emisango. Naye kale tulabe Counsel Elias Lukwago nga yabako gye tuli bwebaddewo mu kooti olunaku lwaleero.
Tumanyi bulungi state yateekamu okusaba kwayo ng'egamba nti eyagala kooti egiwe order egikkiriza okusumulula amasimu ga Dr. Kizza Besigye n'ag'Obedi Lutale mbu baggyemu obujulizi bwe baagala. Application eyo teyawulirwa luli lwe bagiteekayo ne tukomawo olwaleero ewulirwe. Era twabagamba nti muleete omusajja Benedict Odiek eyaswealinga affidavit ng'agamba y'omu ku banoonyereza abapoliisi. Tumubuuze ebibuuzo atunnyonnyole kikyayagala mu masimu ago kutya bwe bagaku n'ebirala bye sijja kwogerawo ntuife ebibuuzo byaffe bye twagala omubuuza. Kitwewunyisiza okutuuka wano nga state bano baprosecutor baga nti tetwagala ebibuuzo ebyo babimulize mu kamera eri nga bannamawulire tebaliwo nga ne public teriwo. Tugende mu chambers tukwate n'enzigi tuziggalewo bateekeko ne kufulu esibireeyo tumubuulizeeyo mu nzikiza ebibeeyo public ereme bimanya. Ekyo kitwewunyisiza nnyo ne twebuuza kiki kye bakweka bw'abanga ddala ayogera mazima nga byayagala bya bujulizi ddala obugamba nti bwaleeta mu kooti lwaki ayagala tugende twekweke. Tuwakanya okusaba kwabwe ensonga zaffe tuziwadde nga tugamba ffe twagala ayimirire mu kabuli wano witness stand annyonnyole tumubuuza akana n'akataano. Naye ate era muwulidde state yo ng'egamba nti nedda bo baagala bagende mu kamera. So kivuddemu omulamuzi n'akkiriziganya ne state n'akola rulingi n'agamba nti okusinziira investigations zikyali ku stage esooka waliwo ndowooza ebintu bye baagala okukola nga byankiso babikolereeyo mu nkukutumu mu chambers. Ffe kyetuwakanyiza tugaa nti bw'obanga osazeewo eno kooti waliyo ate kooti ezisingako twagala kweyongerayo mu kooti kino tukiwakanye mu nkola gye bayita yali vision. Kooti eya waggulu ayi kooti erina obuyinza obwetegereza mu biragiro byonna kooti eno eya wansi byewa
nebaako bwebisalawo oba ebikyusaamu oba ebimenyawo oba ebikkiriza. Kati ekyoffe kyetusabye naye state era nekiwakanya lweru tuli basanyufu final omulamuzi akkiriziganyiza naffe naga nti ayimirize ebyokugenda maaso ne cross examination oba okubuuza mukulu Benedict Odiek mu kamera oba mu chambers okutuusa nga tumaliriza okugenda okujulira kwaffe mu high court era omusango ne gwongezebwayo ennaku za mwezi 3 mwezi ogwokuna okujja mu nation okulaba nga wetutuuse. So kati ffe tugenda maaso n'okukola enteekateeka yaffe okuva olwaleero okulaba nga tuteekayo okujulira kwaffe. Kankuyita kujulira ne mu mateeka tekuba apiiri ne mu Luganda kwekujulira tuteekayo okujulira kwaffe kusalawo okwo okwogamba nti Odiek Benedict bagenda tulina mu cross examiningira mu kamera oba mu nkukutu nti tugenda tekikkiriza era ekyo tukiwakanya ne sekuwakanya. Twagala kiragiro kya kooti eya kooti egambe nti tumuteeke mu lujjudde wano mu kooti ng'amawulire weegali ng'abantu bonna we bali ebibuuzo bimubuuzibwawo kubanga state ye yatandika dde ebintu bino era negenda ng'egira ebintu byejyoteka ku Dr. Besigye kubaka twebuuza yo lwaki state yennyini eyatandika okufulumya ebintu ebitalina mutwe n'amagulu nefulumya bu audio negamba muwulirize simanya Besigye wuuno alamuze emmundu simanya Besigye wuuno agenzaako okunoonya esente Sweden Greece wuuno simanya luddawa zebatandika okuteekayo obuloboozi obwo bagezeeko okuprejudicinga case kakati babuteekayo era mwalaba n'ennaku ezo nga boogera n'ebigambo bingi abasajja nga bamwenda nga boogera ebigambo bingi oyo Besigye yali ayagala kutta Museveni oyo Besigye ayina kino obujulizi bubuno obujulizi tubulina ne bademerako bonna bawulira obujulizi bakulayije bonna bagamba obujulizi tubulina kati mukweka bwaki muluteeke wano mu lujju bw'aba Odiek abulina jangu wano yimirire mu kaguli tugende tukubuuze bugana katano ku bibuuzo lwaki otayagala bagende mu nkukutu. So ekyo tugenda kulemerako era tugenda kooti eyawafu.
State egavumenti muzanya bukodyo okuteeringa justice mwe bennyini
ebyo situjja kubiddamu kubanga ffe twagala obwenkanya. Omanyi ennaku Dr. Besigye n'Obedi Lutale bamaze mu kkomera babakwatanga 16 Novemba omwaka oguwedde ne babatwala mu Joint Court Martial ne tuguba ne tulwana olutalo Sematalo ne tuluwangula ng'ennaku z'omwezi 3 mu January. Ate era ne bajembera ebiragiro bya Bundi nga bazanya jangu okwekula ebya Supreme Court ne baluwawo okuleeta Dr. Kizza Besigye bagambye nti investigations bakazitandika. So obanga wakwata Dr. Besigye ng'ennaku z'omwezi 16 omwezi ogw'Okuna kaka tuli wano mwezi gwa Kuna totandikanga ku investigation otandika butandisi ogamba otya failed to delays. Ani yabalemesa okuteeka ya application yeno omwaka oguwedde? Ani yabagaana okuleeta omusango gino mu kooti ya bulijjo ne baddeyo mu kooti Martial mu Kangaroo Court? So ebyo byonna bya butaliimu bya kuteekawo bintu ebitalina mutwe n'amagulu kwagalako obuddiisa bannayuganda. Naye kugenda mu maaso n'okufaafaagana nabo mu mateeka tugenda kufaafaagana okutuusa nga Dr. Besigye n'Obedi Lutale bafunye obwenkanya tubakakasa tetugenda kussamuka tetugenda kussamu oyo tugenda kufaafaagana nabo. Oluzungu tubaddemu wali mujja kufaafana
kale omulabi waffe omulungi ndowooza nzikiriza nze nkusiibule wano kuba kitandikidde okutuusa wano we tuli ndowooza ensonga zonna ozigoberera era nga ozifuna bulungi nnyo tukwebaza olwakadde kootuwadde obudde bwotuwadde ne kadatako kotaddemu nti weebale nnyo weebalire ddala tojjanga okwo era twala for granted wabula okujjako okwebaza obwebaza ayagala alina business twagala business nkubiraako ku 0800800 business yonna eri mu line ya media bifaananyi video script bulango mikolo nkubirako bukubizi tulabe nga tusobola okuba nga twogerezeganya tulabe tusobola okukola business 0700800 weebale nnyo weebale ddala beera bulungi weeraba.
The problem the Uganda have divided Uganda along these nation issues. So English would be better. Okay. English would be better. Yes. Mbatadde. Mbatadde.
Kanso ku ensonga za Kanso Aaron Kizza ekisooka ku Aaron Kizza nga ye tazirabanga nsonga ze kubanga abadde part of us nga tumurepresentinga application ya bail twagikola byonna byetukoze n'apiiriye nga tuli naye the spirit ya decision eyo etuyambye nnyo nga bannamateeka tukisanyukidde babakwata munnamateeka bannayuganda abeesanze nga ekooti eziteekawo ebintu ebibanyigiriza kuba mujjukire yakola ensonga omusango guno gubadde ku kooti eyagibwawo ey'abannamagye era okuba nti nno kooti yakola ensobi ekirala gubadde gwa bannayuganda ate abakutabwenkanya naddala nga basabye bbeeyi so tuli basanyufu okuba nti Aaron Kizza bamutadde n'ekisinga okuba ekikulu nti ensala ya kooti eringa emaze byonna kubanga ekulaze nti apiiri ya Aaron Kizza erimu omulamwa kubanga ekooti eri byeyakola tebyali mu mateeka ng'ate yapiiri bitwale kyesinza okutuyamba gyetuwadde essuubi nti mu application za bail zonna zetwataddeyo oba zetwateekayo ez'abantu abaali basibiddwa kooti y'abannamagye tufunye president oba ensala ya kooti etugenda okwesigama okulaba nti nabo bava ku kooti essuubi eri bannayuganda nti omuntu yenna alina bano olumanyi bamashete baani abala bonna be tubadde tulwanirira abakyali makomera tufunye essuubi ekirala tufunye essuubi ne application ya retardika no Dr. Kizza Besigye kubanga era basis ya application ya bail mulimu engeri ensonga ze ezakwatibwamu ekooti y'abannamagye so omulamuzi erubu kyakoze akikoledde abantu bonna amutadde kakalu ka kooti ak'obukadde 2 ne bali abamuyimiridde obukadde 5 obutali bwa buliwo n'amugamba nti passport yagiteeke wa registra agende ngayo buli mande bwaba nga aripootinge buli mande obw'obukakulizo si bwe bubadde obuzibu ennyo tufunyemu obuzibu butono ku ky'obukadde 2 kubanga obukadde obw'2 Aaron Kizza ayinza okuba nga abusobola era abusobola kubanga tusasudde kati enyogere naye oli omulala president eyo okuba nti omuntu bakusasula obukadde 2 ku liberty yosimbuliza mu kooti gye bagamba ddala teri mateeka abamu bayinza obutabusobola so tusanyuse kubanga tewali price ya liberty era tugenze mu maaso n'ozisasula naye okusasula ekitegeezezza nti ekyo tetukirabye nti nno si kituufu era tugenda kikwata ku lwakyo n'ebirala byonna tubisanyukidde era twebaza justice erubu kubanga tulowooza ensala gyawadde eyongedde okuwa essuubi bannayuganda ekooti zazzeemu okubeera nga zisala ensonga ezirimu ebyobufuzi nga zisalira mu mazima kuba bannayuganda essuubi lyali lyabaggwamu supreme court bwe yasala ku general court martial essuubi netandika okukomawo naye engeri ensonga gyakwatibwamu gavumenti essuubi neribula kati yemeemu decision ate bino tubikola ku lw'abantu kooti zikola ku lw'abantu buli kooti lwevaayo nekola decision ng'ekoleddwa olw'obulungi bw'abantu naffe bannamateeka bangi bati bakyajja mu misango gyaffe kubanga kino yali ataku bannamateeka obadde olaba nti era singa owetegereza twaba bangi mu masango gino gyetokitakiza Besigye ne waro nyennyini kati entiisa engenderere eri bannamateeka singa Aaron Kizza tebamuwadde bbeere badde ejja kusigalawo ne naye ekendeeza lwaki bannamateeka basanyufu bannabyabufuzi kuba gwalimu ebyobufuzi balina okuba abasanyufu kiina ddala bannayuganda balina okuba abasanyufu kuba bafunye pulezidenti egenda okweyambisibwa nga basaba okweyimirira kakalo ka kooti bulijjo byonna siteeti byeyambisa bibadde mu musango ogwo nti ate abamuyimiridde bali mu mbeera eno kati eno twasembayo okulaba ensala efaanana bweti ku justice omugenzi kati mugayizi ebyo tubaddeko byonna walina Dr. Kizza Besigye lwaki nkyogerako nti omusango gwa Dr. Kizza Besigye twagimusabira bbeeyi 2001 buze gwe tweyambisa nga bannamateeka era kuyambye bangi okuteerwa abalina n'abatalina abalina attention n'abatalina kati decision y'erubu omusango gwa Aaron Kizza attention gye twagitaddeko egenda kweyambisibwa abalala bonna n'abatalina attention ne principles zajjeeyo bulungi mu peegi zino bazibadde 33 zigenda kuyamba n'oli atalina mwasirizi okuteebwa kakalu ka kooti kuba asanguddewo abalamuzi abamu bebadde beeyambisa okuma abantu beeyi especially omuntu nga convict issue agitambuludde bulungi. Which many judges have been shy to consider in admitting Aaron Kizza on bail because it was very clear. Probably the accused person will serve the sentence before even the trial is concluded, now that he has served a third of it. That is a key element. Many Ugandans have, for being denied bail, have served sentences, which is not the intention of the law. And that which is the justification for someone having a constitutional right to apply for bail. But besides that, this has not been a decision of Aaron Kizza. We have not been representing Aaron Kizza actually, because he has been part of counsel. When we were making his application, we were with him, and his law firm is part of the lawyers for Aaron Kizza. This matter has been about the lawyers, because he was detained as counsel for executing his instructions. So lawyers were under attack by that decision of contempt while on duty. Secondly, there are several other Ugandans who are detained by the General Court Martial. The decision of Honorable Erubu, that especially that the appeal emanates out of an illegal establishment. Illegal establishment, procedure, and composition, there is a high likelihood that it will succeed. That alone gives at least a bearing in the other applications that we filed. We are optimistic that other bail applications that we filed and those yet to be filed for persons who are detained by the General Court Martial have gotten a precedent. It will persuade the other judges into releasing our people. The Supreme Court, the spirit of the Supreme Court, it is very apparent. These people who went through the General Court Martial have no business being in prison, but that can be only be through a judicial process. But that we've gotten a precedent today, that excites us. But most important, we do these things for the people. Leave alone, even our bail application for the retired Colonel Dr. Kizza Besigye, because it has a bearing. At least there is in the ratio descendant, in the reasoning of the judge, it has a bearing on the bail application of the file. But most importantly, it's not about Dr. Kizza Besigye, the Aaron Kizzas, and those of the ilk. It's about the Ugandans for whom we are dispensing justice. A Ugandan who was taken to prison by that quasi-judicial role of a kangaroo court, in a court which should have served justice. There's now a decision which is going to predetermine whether they should continue serving or not. Because now, denial of service or denial of bail in Uganda has rendered people to serve sentences, which was not the intention of the Constitution in enacting the right, constitutional right to bail. So we beg other judicial officers to take persuasion from the decision of the Honorable Ruby in dispensing justice for all those prisoners who are in prison arising out of the Frank General Court.
Thank you. Ladies and gentlemen, thank you for being here. It's been tugamba nti mwebale kubeera wano luliwa sakulirayo nze waffe nakulira wano. Alright, oyo Ajat Amina okweyagala kwonna Besigye bakyamusibye. Have a good day. Bulungi mweraba naye temwerabira subscribinga. Mweraba naye temwerabira subscribinga.